Okay.
Okay.
So welcome everyone to the ADR practice section presentation CLE today. My name is Ann Dalton. I am chair of that practice section, and I'm very pleased to welcome you all to another one of our CLEs. We spent a great deal of time thinking about and putting together these CLEs, so I really appreciate the people that are here today. This session is being recorded and it is available on the Lee County Bar Association YouTube website. I want to introduce Herb Freed at this time. Herb graduated from the University of Miami with a Bachelor of Science in Physics. So he is uniquely qualified to tell us, yes, this is brain surgery. He also got his JD from the University of Florida, and he has practiced law since 1976 in Lee County, Florida, along with his wife, Linda Freed, who is a board-certified matrimonial attorney. He's been a mediator since 2006. He is Supreme Court certified in family law, circuit civil, county, and dependency. He's also a Florida Supreme Court qualified arbitrator. Herb is here today to talk about some new techniques that are a little controversial. They're not allowed in Florida, but I know that Herb has a strong feeling about this. And he's here to talk about evaluation techniques exercised by mediators in the state of Florida. So Herb, if you want to go ahead, thank you.
Thank you very much. It was very nice. I thought someone was probably ahead of me in terms of the way you were being introduced to me. Anyway, so I got interested in this because there had been a prior seminar with the idea of using arbitration in the family law setting. And to me, that really didn't ring as an appropriate use of arbitration or for family law, because that is usually they use attorney's fees essentially is the carrot and the stick in terms of, if you don't agree with the arbitrator and you ask for a new trial and you don't do as well as you would have done. And that really is not appropriate for family law, because actually attorney's fees are determined a whole different way in family law. But there is perhaps a need for some advice in terms of trying to settle a case. So I looked at the various mediation forums that are out there, and there's basically three. There's facilitative mediation, which is what we have in Florida. The mediator does not give any opinions. There's evaluative mediation, where the mediator is permitted to give opinions. And there's also something called transformative mediation, which is more of the mediators they focus on empowering the disputants to resolve their conflict and encouraging them to recognize each other's needs and interests. Well, actually, I kind of use that in the normal facilitative mediation we do in Florida. But evaluative mediation is not approved for Florida. A mediator cannot give his opinion. And the question is there a way that evaluative might be helpful or not? I've attached a file which is very critical of evaluative mediation, because I think it's important to know the pros and the cons of evaluative mediation. So it's in the chat. You can open it and read it. And I'll go through some of the issues that it brings up. But basically the idea, and I've had situations where, a participant might ask me, what's my advice? And I say, no, I can't give you advice. Of course, mediators give advice all the time, but they just don't call it advice. If you have a situation where let's say a party might say, well, I don't want to allow the father to have any contact because he yelled at my son and it's not appropriate, and I think he should not have anything more than supervised visitation till the child's 18 and perhaps the child's 3 years old. And so the mediator can ask, well, what do you think a judge would do in the circumstances, especially since you've already said the father's a good father, he just yelled that one time. And then the person may very well say, well, all right, I see, I think a judge probably would allow mediation. And you go on from there. So you're basically pulling out from the party the response that you hope they will give, but you're not directly giving any advice. They kind of read between the lines in the questions, perhaps. So that's what's being done. But in evaluative, if you will, I'm going to stop for a minute, make sure everyone reads that article that I've given you. And then we can talk a little bit more on the other side about it. So let me stop for a moment. And then anyone who wants to start talking about it, please do. The purpose of this is to have a discussion, as I said, among peers. So please jump in, raise your hand. I appreciate it if you actually were visible rather than hiding behind these blank screens, only because obviously it lends itself to a much more interactive presentation. But everyone went blank.
I think there's a flurry of activity on your chatter that says that we don't have the article. If you look at your chatter.
Oh,
It's at the top of the chat.
it's at the top of the chat, yes.
I don't see it.
You don't see it. Go to the very top. It says evaluative mediation. Right above where Lauren Bob had given a note.
I don't have
Nope.
anything.
You may have sent it before people were
Oh,
logged on, and therefore we don't have it if we came in.
oh,
after that.
okay. I didn't realize that was an issue. Okay, I'll
I
send
didn't
it
either
again.
until apparently.
Okay, let me do it one more time.
Thank you.
Thank you for bringing that out.
Who says we don't learn new things on Zoom 2 years into this?
Really,
using it?
there's always room for that. Okay, so I just sent it again. I think, yeah. Okay. Just wave your hand or something if you're done reading it, ready to proceed. All right, Colette. Okay, so that first paragraph I think is very telling in terms of the whole view of evaluative, because basically the evaluative mediator took over, the whole framework of the mediation, showed that at least to one party that this person was not neutral. And, to say that there's no chance of winning when, of course, the attorney for the company believed there was, and in fact, ultimately they did win the case. So that's a good way to stop it, to stop the mediation. My thought was that there is a place for evaluative mediation, but it can be kind of limited, but there's still a place. First of all, you could say, well, first of all, it should only come in, and I believe it could come in even now. If the parties and the attorneys filed a motion with everyone signing a stipulation saying they would like to use evaluative mediation, and name the mediator, so it's all clear what everyone's getting into, and ask the court to allow that mediation to substitute for a true mediation, because in Florida, evaluative mediation is not acceptable. And I believe a court certainly has the ability to say, okay, we'll try it, and then not force the parties to go back to mediation, saying, well, you never really had a mediation. So I think that procedure, and I'm especially interested to hear from Judge Weiss about whether or not he thinks that that might be doable. So it can be done, but what it takes is confidence in the mediator. So the attorneys and the parties, and I'm not sure if I would even want to have pro se parties doing this at all, at least initially, while we really were exploring how it would turn out. And so the attorneys, have confidence in the mediator, perhaps have used the mediator before, believe the mediator is either not overbearing or agrees with that in the position of the mediator. And a primary use might be when an attorney has a client who is too far off of reality in terms of what that attorney thinks his client should be looking for, and needs perhaps a second opinion to help the attorney get his client or her client on track to be able to look at the case reasonably. So, which you can't do now with in mediation. So I think that might be helpful. But what do you guys think? David?
I'm not sure that.
I can't hear you.
Can you hear me okay now?
A little bit more. We need to.
I'll ask somebody else to like this for them.
Can't hear you. Sorry. Can you go right up to the microphone or something?
Is that nope.
Not really. Okay. You just look like you're ready to say something in that. Who else would like to join in? Very good, Judge.
Yeah, I would say, I think that I know within the workers' compensation world, evaluations do occur within the mediations, but it is just, I think, really what you had said, Herbert. And that is in a case where one side is just not looking at it realistically, the lawyer themselves might ask the mediator, well, what happens we go before the judge? What do you think going to happen if we take you to the next step? I know if I was representing the insurance company in a case, I would say, look, we have a really good chance on these few things, but it's likely, if I'm as the attorney, I might be trying to tell them, it's likely the judge is going to give them a little bit, which will then of course hit a big attorney's fee. So maybe we want to move a little bit more. And the mediator would then be asked in essence, would give their view like, well, he's got a point. We can't predict for certain, but if you did get tagged on one of the 5 claims, they're going to get all their hours in the case. So they have to go 0 for 5. You have to go 5 for 5 to win. They need to just go 1 for 5 to get an attorney's fee. So what's that calculation? But I could certainly see the point in this, reading this article where, once that mediator said, oh, company, you're not going to win. Because I'll tell you this, I had a mediator early on in my career. I was over in West Palm Beach who, again, representing insurance company, would come in and look at the phone because the client was the insurance adjuster's workers' comp, was my phone, and go, I have an injured worker over there who's not getting paid, and I have no idea why you're not paying them, and you should be paying them, and then would walk out and kind of leave me to deal with the client going, what the heck was that? He evaluated the case, and I did, after a few mediations, sit down with him and said, you get a lot better if you go to my client and say, they're telling me X, what's your side? And kind of, work the process. And he did a lot better when he didn't just immediately come. He had formerly been a representative, a lawyer for plaintiff. So he was taking the plaintiff side before ever talking to the other side. And what a surprise that once you did that, the other side's, back would go up sort of here. The union said, well, we're going to win based on this mediator. We're not moving. And you're not going to get a negotiation that way. So it kind of is more of an informal process. I don't know in my world whether we get anything on whether anyone would even think to go for what you're talking about, an evaluation, as opposed to do it more informally.
Well, well, go ahead, Doug.
If I'm hearing Judge Weiss right, I agree with him that the way to do it is not to make declarative statements, but to ask questions. I agree with the article. I think it's very bad to do that. And I think you can get to the same place and move people in a more responsive direction to their opponent just by asking the right questions. How, this is what they're saying. What's your response to that? Have you considered this? Is there any way that you can see something that you want that they might accept, and so on and so on and so on? Questions.
Go ahead.
It's essentially the Socratic method made practical, and I think it's possible, and that's the way I do it. And I feel personally very uncomfortable about making the declarative statements.
But that's the way it has to go in Florida. All mediation should, just the way you've described. And there are no mediators who should be giving opinions, even though as a practical matter, sometimes you're aware that some mediators do that they're just wrong. They should not be doing that. It's not.
Well, they do sometimes. And
yeah,
I have a vivid memory of one mediation I was in where the mediator did that, and it made me rather angry.
absolutely.
And I told him so, and I never used the guy again after that.
And exactly, that's exactly the response. But this is a different situation. This is where you have the attorneys and the parties have agreed on a particular mediator, perhaps because they were certainly aware of that style and would like it. Then I can perceive it this way, where let's say the mediator only gives an opinion if he's asked for an opinion as to a certain thing, that that mediator might help an attorney convince his client to do, as I said before, kind of the right thing, not be unreasonable. But it would not be through the mediation department because it's not a mediation. And the only question is, will the courts allow it as an acceptable substitute for a mediation, so that when you're done with an evaluative mediation, they don't say, well, you still haven't done a mediation, so I'm now going to order you to do a mediation. Judge?
Yeah, I would just say that, again, in workers' compensation, I mean, if parties, we have state mediators that, that are in my office, and I'm substituting out private mediations all the time for, to take place instead of the state mediator. So I know for me, if a state came to me and said in that motion to substitute that it was going to be an evaluative, candidly, I wouldn't care. I would say, you're holding a private mediation, whatever you all decide to do. Certainly not going to speak for the circuit county judges and what they might do, but I could only imagine that, again, if the parties are jointly agreeing to hold a mediation with a private mediator in place of what would otherwise be required, and they want the mediation to be a certain way, and they've agreed, I know for me, I'll sign it. It's fine with me. I'm not going to have them, if they do a private instead of state, that's just it. It's instead of. So at least again, in workers' compensation, they'll move forward if they don't settle. They don't have to go back and mediate again.
Judge, if I may, I'd like to ask you, if you will, to tell us a little bit about the practice you're doing right now and kind of your background. We're not all familiar with you.
Right. I'm a judge of compensation claims. It is workers' compensation under Chapter 440. So if you get hurt on the job and the insurance company hasn't provided you the benefits you think you're entitled to see a doctor, medical treatment, or money benefits for having lost wages, you file a claim. And when the claim is filed, it's called a petition for benefits. 40 days after it's filed, we're going to give you a notice for mediation that by law has to occur within 130 days. You have the right, though, to mediate not by our mediator. You can hire whoever you want to, and then you file a motion before me and I'll substitute that out. If you do not reach a resolution of the issues, then a pretrial will be held and a trial will occur before me. We call it a final hearing. It's a trial on the issues. And that trial has to occur within 210 days of the petition being filed. So we move things pretty quickly, and we can move it, we can continue beyond that, but the statute, there were problems years ago, just kind of when I started in the mid-90s, where claims would be filed and not heard for years. So they in 1994, they put in place stringent requirements of 210 days. And I typically, I'll average, well, attorney fee matters get with it as well. So I'll typically average about 175 days, but without the attorney's fees, the trial is probably heard between 180 to 200 days of when it's filed. And that does mean, of course, that some are greater than 210 days. But most of them on the short end, they'll still get about 6 months from being filed. We just move it very quickly. But you do have to mediate. We did require under the law, mediations must occur. And when I first came in the mid-90s, there were plenty of the lawyers at that time were like, no, this is not conducive to mediation. And now I'll get requests from people when there's nothing pending. Could we come in and have a mediation? We don't want to pay for it. Could we come in and, the state mediator has time on their calendar. Can we just come in and sure, that's available.
I have one question, which I think is on everyone's mind at this moment. How does one become a mediator for the mediation for the workers' comp?
Well, for our system, we do have periodically there are job openings. In fact, right now, the mediator who is working with me has left. The job, it's not been posted. What a surprise. We are certain waiting as a state agency, waiting for the budget to be finalized before we start filling positions. But it would be something on the Florida Job Board, wherever that is.
So this is a full.
It is a full-time position.
Job. Oh, okay.
It is a full-time position.
Okay.
It's a full-time position. As far as private mediations, that's just simply, particularly those who have any experience in workers' compensation matters, just kind of hold themselves out and however they get business, and then people can hire them. And once that happens, typically if it's in place of a state mediation, you should, before the state mediation, file the motion to substitute. I have approved a handful where it occurred afterwards. And as the state mediation date was coming, like, well, we mediated though privately 2 weeks ago and they don't want to come back in. And so I've signed those, even though the law says you're supposed to do it beforehand. Again, the parties are in agreement. You mediated. That's all the law requires. And if you have a mediation report that says, yes, they showed up, that's good enough for me.
All right. Well, thank you very much.
Sure.
Colette, I know you're anxious to tell us what your thoughts are on evaluative mediation. What do you think?
I think it's great as long as it's not determinative. And Dalton in particular does a really, really good job of pointing out each side's really negative points. So she's very evaluative. I don't know if I'm going to get her in trouble, but she's very evaluative, but in a questioning, well, what if the judge took this position? And she points out each side's really big negatives, not positives, only negatives. And I think it's really good for the clients to hear that.
I assume that's when you're in caucus, and
Yeah.
and I assume if it's with questions, that's not evaluative. She's not giving you her opinion. She's asking questions.
Well, potato. I mean, call it what you will, but I and clients will take it for what it is. It's an evaluation of, well, this is what she's seeing, and maybe the judge will see that as well. And I think clients need to hear those things. I think those are, I'm for it as long as it's not declarative. I think it was Mr. Friedman who said, as long as it's not declarative. Maybe it was Mr. Wilson. What somebody said, maybe as long as it's not declarative.
Okay. And would you like to give us your method of how you give your opinion without not giving your opinion?
Well, first I want to say that I'm 100% opposed to evaluative mediation, Herb, as you know, because we've had this conversation.
Yes.
I just ask questions. I say, what do you think the judge would do? And if I have a counsel who appears to be relatively inexperienced in a particular area, for example, if they they got into some type of a dispute with a neighbor over a fence or something, and they don't normally do that kind of work. I'll take the two attorneys out, well, when we did in person and now in Zoom, and just have the two attorneys talk directly about what they think that judge would do, which is a graceful way of saying, whether or not you know the law, that the judges all have, have their own way of applying laws. And that's really more of my technique.
I changed the microphones. Can everybody hear me now?
Yes, very good. David, go ahead.
All right. I retired as a magistrate a little over 2 years ago. So I'm doing this on a part-time basis, and I don't expect to apply for a full-time job anywhere, even if it was even if it was working for Judge Weiss. When I was doing a lot of family court, both as a practitioner and later as a magistrate, I remember seeing a case, I think it was out of Hillsborough, in the contempt context, where there was an administrative order entered by the chief judge, which basically changed the law. And the appellate court said, you can't do that. So I'm not sure that it would be, I don't want to say it's inappropriate, but I wouldn't expect a circuit judge to easily be convinced to approve of a process that was contrary to the limitations set forth in our mediation statutes. I understand Judge Weiss's point that if they don't come to me and they go private, I don't need to know. But asking for court approval, I think, runs afoul of the authority of a judge to permit it, wink, wink.
When you put it that way, I can agree with that. But the way I'm envisioning it, you're not approving anything. You're just saying you're going to remove the requirement of having a mediation in those cases where people do this type of whatever it is. So all you're doing is deleting a requirement of mediation. You're not putting your onus or your approval on anything. If they want to do a procedure and they ask you, you know what, I'll say I'm not going to need a mediation because I think it's been clearly explored in terms of possibility of settlement. So it would just be a waste of time to have them do a similar thing a second time. So all the judge is doing is saying, I'm going to delete the requirement of mediation in your case.
I think I'll go back to the point and state it differently, that when you ask a trial judge to do something like that, you're sending Pandora's box down a slippery slope right into a moral hazard. Where does it end? How many other parts of the mediation statute do we want to say delete just this one time? I don't see it happening within Florida.
Well, the point is the slippery slope would be viewed at by the judge in the particular case as whether or not that is something that in fact is a useful technique or not a useful technique. They can say, we want to go to the top of Mount Everest and talk to a shaman to get a result. Will that be instead of a mediation?
That's cold.
The judge could say, sounds good to me.
All right. I guess you and I disagree for the purposes of this discussion.
Okay.
But I see it as Ann does. Within the territorial limits of this state, no judge should even be considering it.
Okay.
Go private.
Would you, that's advice to a judge, but would you say, if a judge did say, I'm going to release you from the requirement of a mediation in this case, does he have it within his power to do that?
I don't think so.
Okay.
Okay.
Good point. All right. Well, as you can see, the reason I attached that particular article was because it is a controversial thing. I'm not necessarily saying it's a good thing or not a good thing, but for those people who need perhaps more advice and don't want to go to, I just saw arbitration as a total terrible thing if that was to go towards anything, and this kind of might relieve the pressure on that if they, if the attorneys wanted to do it, and since they control who the mediator is going to be, obviously it has to be a style they approve of and they're looking for. And if you had a client who seemed unreasonable and you can't convince, even though they paid you all the big bucks, so you still can't convince them to do the right thing. I can see it as being a reason for doing it. And the other side would agree because they know where you're going with it. So, okay, good. Well, that's the purpose of this thing. By the way, while we're talking, I just bringing it up, and I'm not sure that's even necessary, but just as we have a number of mediators here who are talking about something, in arbitration, I've been doing for about 1.5 years, every 2 weeks, a meeting of arbitrators. And Karen and others, Doug, are all there, and we talk, and it seems like a good group. And there's some technical issues that really we seem to have to go over again and again, and because things seem to change. I don't know if that's something that we might want to do as mediators, but if it is, let me know. Send me an email or something, and maybe we can set something up. But I don't know. It's just a possibility. That's all. Mr. Dean, Jonathan Dean. Hi, I don't know that I've met you before, but do you have some thoughts on this as evaluative mediation?
I've done some mediation. I am not a Florida lawyer, but I am a Florida mediator.
Okay. What do you think? What do you think in terms of the evaluative process versus the proper mediation?
Well, I think the statute is what it says. Although I tried to reschedule a mediation, which looked to me as if it was something I could do as a mediator, but under the statute. But the mediation office said no, and the mediation office, from my point of view, is as significant as the judge. The process is a very valuable process. I am absolutely persuaded of that.
Okay. What's your background in terms of mediation?
Well, my legal background was as a lawyer for a couple of large companies over a long period of time, and it's not all that useful because most of it was international work. But I actually was involved in a lot of mediations for before the NLRB. Which were kind of interesting because in the cases where the claimant was unrepresented, the mediation tended to go my way, although largely that was because my client was right, so it was all right, but I felt a little uncomfortable. But the nice thing about them was if there's no lawyer on the other side, you don't have to do a deal that requires financing the legal work for the claimant. So you can come up with something that if there can be, in many cases, there's a solution that makes sense without having to pay, without paying any money, just improving the claimant's career if it's an employment issue. And if there's no lawyer on the other side, you don't have to pay money, and makes it a lot easier on the client. And a lot of times the money is really because the lawyer has to be paid.
I've also found that when the other side doesn't have a lawyer, it's a lot easier to get past some of the legal issues.
Yes.
But sometimes not any different in terms of outcome though. Okay. Karen, I haven't heard from you. See, I get to sit here and I can just pick on people like
Hi there. I mean, I think our hands are kind of tied because the statute says what it says, and I don't know if it practically makes sense for judges or others to go around it. But I guess my question is, it seems like the experienced mediators can kind of get to the same point without stating their determination. So I'm not sure how necessary the, quote, evaluative mediation would be. I mean, it seems get the same point across within the statute. So I'm just not sure how necessary the whole exercise would be to go around the statute. Because I kind of agree with David. I don't know that judges would be inclined to do that. But I also don't know that it'd be necessary. I mean, if we can get the point across with the questions or, with the discussion with just the attorneys, I think you can get there anyway.
Yeah, I can see that. It did occur to me that right now you can petition the court to waive mediation, and you can file a motion, and there can be a time when a judge can waive it. Basically, if they believe it's unnecessary, if it's not going to be productive. I mean, it takes a lot, I think, before they'll waive it, but it is within the realm of the judge to decide to waive it. So I think there's enough legal precedence that would allow it to be done, but convincing the judge that it's an appropriate thing, that's another story. If you can't
Well, in
convince
our
the judge, it won't happen.
In our circuit cases where, we do the arbitrations, they still mediate. And so you still have both the proceedings. I mean, it may be an option if the attorneys feel they need some type of evaluation to have that and still go to mediation. I mean, I think the arbitrations, obviously we all agree are very effective, but there's still the requirement that they mediate if sometimes before, sometimes after, but that requirement's still there. So we have both proceedings.
But they're two different things. And the arbitration, you're going to have a decision, and that decision typically one side or the other says they object to it and they go on for a new trial anyway. And my belief is that that's still useful. The decision goes through the logic of the position, and I believe it's very useful towards reaching a settlement ultimately. But in terms of determining which way, I mean, it's just the logic of here's essentially a second opinion on for us how the case would go. But
so maybe they can have.
Go ahead.
Maybe they can have that anyway without eliminating the mediation. I mean, the attorneys could say, okay, we want to hire someone to do an evaluation. Just do it. And, maybe on their own after that, it's not called mediation, but there might not be a need to do anything formally with the courts. If the attorneys want to hire someone to whatever the label is going to be, do that. And, if it's not successful, then there's still the court mandated mediation.
Right. And that's certainly an option. My thought was, if you're going to go through all that, and then after that, you realize we just can't settle this, you'd petition the court saying, well, we tried this. It's we're not going to be able to settle the case. If you do it ahead of time to know, the judge could still say, no, I'm still going to require mediation. But if you could do it ahead of time as a petition signed by everyone and identifying the mediator, saying, Judge, if we were to, would you allow this mediation or this quasi mediation to substitute or this, for the requirement of a mediation? You might get an answer. Some judges will say yes, some judges will say no.
Wouldn't the mediation, even if they had the evaluative conference to begin with, and there's mediation, isn't that cheaper for everyone than going through trial? I mean, it seems still to have the mediation. So I guess I'm just not seeing how necessary it would be to request the evaluation substitute that. I mean, I don't necessarily agree with mediation anyway, but if the parties want to do that.
You wouldn't need the pure mediation if you have the evaluative mediation. If everyone's on board and saying we trust this mediator to be knowledgeable about it, to give us some advice, and in the midst of the mediation he's giving advice or she's giving advice, then you're as close as you're going to be to trying to get a settlement. Now, once it's over, if it didn't settle, the parties can always contact each other to try and settle, or they could try a second mediation. But at least to them, they've already expended their energy on trying to settle this case. I mean, the mediator of whatever kind is trying to get the parties to come to an agreement. And
I think it's possible that the scenario in the article could happen. And so a second, Florida facilitated mediation might have a different outcome that would be worthwhile. So I kind of view it as the arbitration and then the mediation. I mean, oftentimes after the arbitration, people settle anyway because they hear that evaluation. If they don't, they still have to go to mediation. I don't see the need to request, an elimination of that mandate.
Well, you wouldn't have an arbitration in a family law case.
And in that scenario, whatever the evaluation is that you're going to call it. But I kind of equate it to the circuit civil proceedings, where they do have two proceedings, and I think both are effective and both are useful. I don't do family law, but your point totally makes sense to me that arbitration wouldn't be appropriate there. So you like the idea of something like evaluative mediation, whatever the appropriate term would be. I don't necessarily see anything wrong with that. I just practically don't see a need to request eliminating the court mandated mediation as well. If you want to do both, do both. If not, I don't think the court is likely to or should eliminate the mediation, the Florida facilitative mediation.
And the only question is whether or not you know, if you've already gone through this evaluative mediation and you have not been able to settle it, what would you think? Why would you think another mediation would help? And is it a waste of time? And on that basis, you're asking the court to waive the requirement of the normal mediation. But again, it's up to the judge to do it. I just, you know, just thought I'd bring it out.
I think it's certainly a helpful option if parties want to agree to that. I think it's very different than mediation here. So I don't think the mediation would be a waste of time. And I think they should be viewed separately and different. I don't think there's necessarily a problem with having the evaluation, but I think the mediation is completely different and would not be a waste of time to have both. I think.
What if it was an evaluative mediation where the mediator agreed not to give an opinion unless specifically asked for by one side or the other, and generally in caucus? What if it was that type of, that would be very close to a standard mediation with a little flurry, you know, of if asked for the opinion.
I think that would be really hard to have a kind of streamlined way to address that with judges waiving it. That's so specific. I think it would be hard to identify very specific areas, very specific ways of how you're going to do it. I think more likely the judge is either going to allow something in place in the mediation or not. I think if it gets that detailed, it's a little more, I don't know that would.
Well, the judge wouldn't even need to know about the procedure in the mediation other than it's evaluative. So the mediator has the option, if the parties agree, to give an opinion. And it's agreed by all the parties to do that. I mean, one of the basic principles of mediation is, the parties develop proposals to have a settlement. And one of those might be having an evaluative mediator. That's, in a sense, goes along with the whole theory of mediation. And it's not as saying, we want like a binding arbitration. We want a binding mediator, that this mediation is binding, he gives an opinion, and we're stuck with it. It's not that at all. It's just recommending, based on what the opinion is. The party to the mediation is under no requirement of accepting that. And in fact, the mediator runs very close to having the parties walk out if it appears that the mediator is not impartial. So I think it's David, you look like you're about to say something.
I think I don't know how you managed to stand on that little needle and not fall off that pin.
A lot of practice.
I just don't see a really strong distinction there. At any point, you're asking a judge to allow a mediator in Florida to give an opinion.
No.
Even in caucus, it crosses a line.
Well, in caucus, at least you're not affecting the other side. You can perhaps speak more freely as far as these are your problems with your case, but you're not. I would not use the word mediation at all in those. I wouldn't call it an evaluative mediation. I would call it an evaluative process, some other name, so that it's not confused with mediation. You're just saying it looks, smells, and walks like a mediation, except for it's got a limp, and so it's very close. And the reason you go to mediation for the parties to come up with an agreement that's acceptable to them, those are all present in an evaluative mediation. It's just that they're asking for an additional, perhaps you could say, a push in the right direction And does that disqualify it? In Florida, it disqualifies it from being a mediation. But is it enough to say, all right, I can see if you've done that process, you have exhausted any possibility that a mediation would be effective. So I'm going to let you out of that requirement.
It took a long time for collaborative law to be set in stone in different rules and statutes. I think you should be on some rules committee because until this process that you're creating is a creature of rule or statute, I hate to sound really conservative, but I am on this one. I still don't think that you can call it something that you think is a good name for it and get a judge to approve it until the judge can look at a book and say, oh, there it is.
Well,
Sorry.
there are a lot of articles on evaluative mediation. They are allowed in other states.
Right.
Not all states, but there are states that allow it.
Okay.
So there is a history and a background of evaluative mediation, and you end up with articles like the one I shared, which are absolutely against it, and there's others that are absolutely for it. So, so that it's out there. It's a question of, is it a possible alternative towards solving the problem of the case? And if you can tell people ahead of time, well, if you do this, I'm not going to have you waste your time with doing it a second time. It might be effective, especially the parties on their own, and it's outside of the mediation department. The parties on their own are picking someone they have confidence in and have perhaps used before, and so and can stop giving opinions, tell them to stop, and to do that just to reach an agreement. So I think it's it can be as subtle or more, but it does allow opinions. I would not allow it for pro se parties, because I think then the mediator really takes over them, and the pro se doesn't know, what, it doesn't have any balance with their own attorney. But if they're both represented, this is the way they want to do it. I think that you could file a motion to not have a mediation if you can show a judge that you have effectively had a process that's very similar to mediation, and you've exhausted all possibilities, and therefore you're asking, and you can do that now. So it'll be up to the judge. Judges will decide for themselves whether or not this seems like a possible or not. Anyway, that was my thought. I was bored one day and I came up with it. What can I say? All right. Anyone else like to come in and give their thoughts, or if I haven't been beat down enough, you can add your bat to the.
The only thing I'd say is I don't think anybody in the workers' comp world would ever know enough to actually file a motion before me asking for private versus estate, because they wanted to do evaluative. But even if they did, I have to admit, as far as with the laws and all, I'm not sure that I would really, I don't know with the number of motions that come through with private for state, whether I would even candidly see it, that they're asking for a specific type of private. But, we have it differently in that we are mandated by state and we provide mediators. And I know my mediator is not going to sit there and do any true evaluative as it looks like
Right.
in the system.
Right.
My mediator, when she was here, or the other mediator who is here now, they may be asked, well, what do you think the judge would do with this? And you really can't give an answer.
You can't. You're not allowed to.
But they certainly can, it depending upon who's asking, well, you can ask your lawyer what their experience is.
In your
But-
system, I'm sorry, in your system, is it a mediation a requirement, or is it up to
Yes.
the judge? It is
No,
required.
it is required, though they can ask for the mediation to be waived, but that actually isn't my call. That goes to the chief judge of the workers' comp system.
Okay.
They file a motion and ask for it to be waived. That's very rare, because all they know, especially in today's day and age where almost everything's by telephone, really since COVID began, everything went by telephone. And now without my mediator here, the mediators hearing my cases are in Gainesville, Orlando, they're all throughout the state. So they're all by telephone.
Is it
So-
telephone or Zoom? Is it Zoom?
Most of the mediators for the state system are actually doing it via the telephone and not Zoom for the state mediations. The camera I'm using now is supposed to have been shared with my mediator, but about a year plus into this, year and a half, they set up a system where I can do a hybrid hearing. I've got a big screen that's behind my computer monitor. So I could have half the people here and half the people, or one person here and everyone else by Zoom, or one by Zoom and everyone before me. Since then, no, nobody's wanted to move the camera because it got set up by our IT people, and I'm not touching anything. I'm leaving it. But yeah, how much does a camera cost at this point? If they wanted to do it by Zoom, but for the most part, the mediations, as far as I know, statewide, have all been via telephone. And since the way we set them, they're anywhere from 30 minutes to an hour. So the parties know if they think they need all day, they're going to file a motion to substitute, and they're going to hire and pay on their own for a private mediator. But when they come before in my system, they're not paying anything. It's the state has paid for the mediator, gets a salary, and there's no payment, and they're not allowed to take money. So you can't even, no tips, no tips. But you can waive it, but most people know, especially if you're doing it by telephone, it's probably a lot simpler to show up, listen for a few minutes and say, I'm sorry, we're not, we don't agree to resolve anything. We're not going to offer any money to settle, or we're not going to make an offer to settle. And we just want to go before the judge. And 15, 20 minutes after you start, I mean, the requirement for us is you need to show up. As long as you appear, you've met what you have to do. So that's a lot simpler than trying to sit down and draft a motion that the chief judge is going to approve to waive mediation versus sitting in your office, call in, get your client on the phone for a few moments, and then go on with the rest of your day.
That's a good point, actually. Yeah, I can see that. All right. Anything else anyone wants to add? I can tell you, I'm not going to be pursuing this. So I've been, I'm slow, but I'm not. Anyway, I'm not deaf. So
Lauren wants us to buy our bench barbecue and shrimp boil tickets at the Alliance of the Arts on March 26th, in case she didn't want to pop in and say that. So.
Oh no, I'm glad. Hey, if it comes from a judge, it's going to have that much more weight. So great.
Oh, yeah, no, that was not any endorsement. I was just reading. Sorry.
Okay.
That could not have worked out any better for me. Thank you.
Okay. Actually, I hadn't even looked through the. Okay. All right. This has been great. I appreciate it. And I'll turn this back over to Ann.
Thank you very much, Herman. Interesting discussion. And I do want to echo what Judge Weiss said. Lauren has reminded us all to please get tickets to the annual bench barbecue and shrimp boil. It's a lot of fun. We have a judge that usually handles the spices, and he's a great guy. And no, not you, Judge Weiss. No, you're not on the hook. And we also have a dunk tank. We're not exactly sure who's going to be in it this year. But in any event, the entire event takes place at the Alliance for the Arts on March 26th, which is next Saturday, not this Saturday. Starts at 12 o'clock noon, ends at 3 p.m. And Lauren has reminded us it is all you can eat and drink, but I do believe that they are soft drinks. If you read the Res Gestae this month, you know that the history of this event has included hard drinks, but I think that's been gone for a number of years. So on behalf of the ADR practice section, I do want to thank Herb Freed, and I do want to thank everyone for showing up to this CLE. And if you have missed part of it, or if you're contacted by folks that have missed all or part of it, it is available on the Lee County Bar Association YouTube site. And if you do not receive your CLE credit certificate in the near future, please contact Lauren. She is totally and completely maxed out with a variety of events that are going on. This is a big time in the Lee County Bar Association. And as executive director, she is pulled in about 500 different ways. So if you haven't received your certificate, please be patient, and she will get to it when she can. So with those comments, I'm signing off. It is 12:55, and we are concluding for today. Thank you very much.
Thank you.